Hello, and welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is attorney Naomi Comfort, and we're going to be talking today about handling retirement accounts after a death. This is a great big subject, and so I just want to caution you, as I usually do, that we're only covering a few highlights. This is an enormous area, and this is just a starting point to learn about some of the issues. And we want you to get qualified tax and legal advice. So with that, Naomi, welcome.
Thank you, Mike.
And Naomi is an attorney with Hawks & Comfort, LLP. She has taught continuing education courses on fiduciary income taxation and has made team presentations with Michael Gray, CPA, about handling retirement accounts after a death to lawyers, CPAs, and the public. And that led me to ask Naomi to join me today to discuss this topic. So thanks again, Naomi.
My pleasure.
Okay, so I'm going to go ahead and get right into our questions. We just have a brief time as usual. First of all, aren't retirement accounts handled as part of the process of probate or trust administration?
Well, you know, Mike, when somebody passes away, a successor trustee or executor or administrator needs to take care of transferring the assets that were in the decedent's name to the named beneficiaries under the will or the trust or whatever. Mm-hmm. These retirement accounts, while they're part of the decedent's estate, for example, for estate tax purposes, they transfer pursuant to contract, pursuant to the beneficiary named on the beneficiary designation form that the account owner has filled out during their lifetime. So what happens is they're not, unless the trust is named as the beneficiary on that form, they actually are transferred outside of the trust account. So if, for example, I, as the participant or the owner of an IRA account, if I had an account that I named my husband as the beneficiary of that account, then when I passed away, he would contact the plan administrator and they'd send him forms to fill out so that that account could be transferred to him as the beneficiary. On the other hand, if I had named my trust as the beneficiary of my IRA, then the successor trustee of my trust would fill out those forms and handle the transfer of the account to the trust. Right.
Okay. So why do retirement accounts need to be considered and handled soon after the participant dies?
Well, these are tax-sensitive accounts, and anything, you know, you say the word tax, everybody knows there's deadlines associated with it. You miss a deadline and you've got either increased cost, you've got penalty, you've got something going on. So it's a tax-sensitive account. Remember, when you set up and make contributions to your 401k or your IRA, that money goes in pre-tax and it sits in that account and it grows without paying any tax. Well, after somebody passes away, then the beneficiary is going to have to start taking distributions out of that account. If the beneficiary doesn't do that timely, they're going to get hit with penalties. And those penalties are 50% of the amount of the distribution that should have come out. So they're very, very hefty, ugly penalties that attach to these accounts. So you really, if you are a beneficiary of one of these accounts, you really do want to get some early guidance from a CPA or an attorney regarding what's the appropriate way to handle the distribution of the account. If you simply contact the plan administrator, they're going to send you a form and you're going to fill it out and you're going to check a box about, do you want it all now? Do you want it to be, you know, held as an inherited IRA? Do you want it spread out over 5 years? Do you want us to withhold taxes? And the plan administrator can't give you advice about what you should do and how would be the best way to handle that. You need to meet with your CPA or an accountant who will give you advice based on your circumstances, your financial needs, and the assets that are in the account.
Right. And there was another thing, as I recall, that in some cases we want to divide these accounts, and we have just a very short period of time to do that, basically, what, the 9 months after death?
Correct. We've got to get those accounts. If the beneficiary designation has multiple persons or entities named as the beneficiaries, there's some real tax advantages to moving quickly to meet the deadlines of September 30th, I believe it is, to get those separated because they get different treatments. So the beneficiaries, depending on who's named, they might be able to stretch out those distributions over their actuarial lifetimes, or they may be forced to take it out in a lump sum or in 5 years. Now, you know, if I'm the beneficiary of a $1.5 million IRA account, what I really don't want is to have to take a lump sum distribution of that entire account. If I have to take $1.5 million, that's all ordinary income to me the year that I take it out. That's a huge, ugly tax hit that I have to pay, plus I lose that benefit of the tax-free compounding inside the account. So it's very, very important, you know, to get that guidance early to make these determinations, because a lot of times those beneficiary designation forms, unfortunately, a lot of times they are filled out without the guidance of an attorney. And so the participant, the owner of the account, might not have set up the best tax planning with respect to this account. And so you get that guidance early as the beneficiary as to what should be done. You really could extend the benefits that that account gives you. Because once you take the money out, it's taxed, so you lose a chunk of it to the income tax, and then you lose the tax-free compounding that you would have gotten inside the account.
Right. And one thing, you know, I mean, you've talked to me about cases even that you've handled where people are dealing with a death situation, and so one, there's just a problem of, you know, the grief process and so forth that causes delays. Then there's also, if there's disagreements about how things have been set up within the family and so forth, and you may have litigation and stuff there. So if this stuff sort of sits on the sidelines, as can happen,
Correct.
you know, we're all human, then we can have a lot of difficulties because of it.
Right, and there are so many things that could get in the way of this being promptly handled. I mean, for one, maybe nobody knows about the account.
Oh, yeah.
You know, maybe we don't know about the account. Maybe there's a dispute as to who is the designated beneficiary. Maybe the decedent had filled out the beneficiary form about who is the beneficiary. It got lost in the mail and never made it. Or there was something defective about the way they filled out the form and it was returned to them, but they never got it finalized. There's so many things that could come up with respect to that. Then if you have, maybe you have an estate tax return that has to be filed for the estate because you have a taxable estate. Well, as I said, this account, the IRA, is handled outside of the trust and outside of the probate and can just be transferred to the beneficiary. It's still subject to estate tax.
Right.
The personal representative of the decedent's estate, whether that's the trustee or the executor, is responsible for getting those estate taxes paid. And we can run into problems where that account, that big IRA account's been transferred to the beneficiary who's not cooperative in getting the money back to the trustee to make those payments that need to be made on the taxes. Or maybe we've just got a whole big ugly mess with the litigation with a spouse from a second marriage, kids from the first marriage, who gets what, how are we dividing it? Maybe there's a quadro from a divorce and an ex-spouse that is getting a piece and they're entitled to it. There's so many things that can go on, but I've got to tell you, the IRS, when these accounts were first starting to be utilized, the rules were very, very, very complex. They're still complex, don't get me wrong, but they were so complex that nobody understood them at all. And if you made a mistake and you missed a deadline and you didn't follow the timing rules, you could apply to the IRS and get the penalties waived, and you could get a lot of relief from the IRS. But I'm telling you, the cases that are coming down now, the private letter rulings that the IRS is issuing, where somebody's coming to the IRS and saying, please, I didn't understand, we were busy with these other processes, or there was so much grieving going on, we missed this deadline, please forgive us, you know, mea culpa, mea culpa. The IRS is not forgiving on these things right now at all. So it is really important to hit these